This is one of the few and only known photos of Henrietta Lacks. As is finally well known, in 1951, Miss Lacks, dying of cervical cancer, had a biopsy taken of that tumour without her consent or her knowledge or any information given to her. And that biopsy provided the first immortal cell line. Miss Lacks changed the world. But that cell line has generated over 17,000 patents, and that biopsy is found in most labs in the world, and their worth is incalculable. But Miss Lacks never received any of that benefit or even any acknowledgement. And in case you think this is old research history, in 2013, researchers published again, without any consent or knowledge or permission, the full genome of the HeLa cells, comparing their DNA with that of healthy human cells. Following widespread concerns about privacy and autonomy, given that the family genome was identifiable, the paper was removed and the genetic policy for the cell line finally negotiated with the family, with a foundation set up to both acknowledge and provide attribution for their contribution and control how those cells were used in the future, including widespread public access. While early genetic research has focused on single gene disorders, the development of high-throughput, cost-effective gene sequencing techniques, together with the Human Genome Project, has enabled a paradigm shift in medicine and medical research towards genomic research, with developments in computer technology allowing processing of really vast data sets. Genomic research has shifted focus to population-wide studies and personalised medicine. Genomic research typically assesses variations using genetic markers called single nucleotide polymorphisms, SNPs. We like acronyms too in Australia, it's okay. To target multiple development pathways for conditions or attributes, known as genome-wide association studies, GWAS. Variations are compared in different populations. If the variation is found in the population exhibiting a particular condition and not in others, the variation is likely to be implicated. However, it requires extremely large DNA profiles, numbers of DNA profiles, and associated databases of individual medical, family history, environmental and lifestyle information to be successful. Biobanks. Although early biobanks were linked to particular research institutions or projects and comprised primarily of biosamples, they've now morphed into largely repositories of biodigital data, combining sequenced DNA together with associated individual data. Through multiple investigations for each proprietary database, new correlations are drawn, not only for biomedical research, but also for phenotyping of physical characteristics, cohort ancestry, and development of new diagnostic and technical treatments. Thus, it's been moved from being rooted in the body, from excised tissues, samples, blood, to epigenetic research that requires not the body, but vast factors correlated to individual profiles, bioinformation. These biodata profiles are vastly profitable. In 2015, pharmaceutical company Genutech paid a direct-to-consumer company, 23andMe, US $60 million for 3,000 profiles of consumers with Parkinson's disease, around $25,000 per profile. For bioactivists and biolegal ethicists, this profitability has reinvigorated legal and ethical questions about proprietary and non-proprietary rights in the body, and including ownership and control of exercised human tissue, privacy and autonomy. There are also legal questions, and we've heard about biosimilars and MGR, and the same sort of things happen in epigenetics, about biological sequences as a whole, whether they are patentable or can be patentable, and what legal strategies researchers and biotech companies can use to protect their investments. For property rights, whether genes or genomic information can or should be patentable remains unsettled and jurisdictionally dependent. What rights exist for an individual in their body or separated biomaterials is even more muddled. Judicially, following Deadwood and Spence, Australian courts have historically held that there were no bodily property rights, except they're carving those out with increasing regularity, looking at social values, technologies and sciences. Given parallel developments in research that have shifted from biospecimens to biodata, it's timely to consider what property rights a person may have in their body and whether body-based law is applicable or suitable in a biotechnical age. Although there's been considerable academic and jurisprudential attention paid to the ownership and control of biospecimens, mostly by Dr. Rimmer, it has tended to focus on rights related to innovation and commercialisation in the public sector, biotech and pharmaceutical sectors. But there's also been considerable controversy in biotech IPR over patents over genes and gene technology, but it's centred on that contested balance between supporting innovation and investment through intellectual property rights and maintaining open access to the scientific commons for public and social good. In the US, the Supreme Court's first code-level determinations of patent eligibility for biological sequence ultimately barred isolated DNA patents in the US, while granting protection of cDNA, complementary DNA, based on the inability to patent naturally occurring substances under their constitution. The Australian jurisprudence, on the other hand, has recognised limited patentability in genes, excluding genes or gene products that are naturally occurring, but including products that fall under a manufactured banner. I just realised. While in Europe, genes mostly remain fully patentable. For diagnostic methods and by extrapolation for GWAS studies, the position also remains ambiguous and unclear. In the US, in Myriad, the patent claims that diagnostic methods were about comparing or analysing DNA sequencing against reference sequence and to determine the presence of the mutation of the predisposition was rejected, holding that they do not apply to the step of comparing the two nucleotide sequences in the process, rather that is the entire claim. In Mayo, the Supreme Court, the Federal Circuit Court, confirmed its earlier decision that the diagnostic disputed claims were patent ineligible, rejecting claims of methods using scientifically routine procedures because adding a routine activity to a law of nature or a clearly understood scientific method was not patentable. In Australia, the issue has not been as contentious. The equivalent Myriad patents were litigated in Cancer Voices, and the disputed claims only related to isolated naturally occurring DNA and CDA. Although the patent claims were nuanced differently, there was the same effect of comparing or analysing a sequence against a reference database and a reference sequence, and identifying an alteration. Without the threshold needed for transforming unpatentable natural correlations, the High Court found that the outputs were a useful product resulting from the working of a method, and thus the GWAS output is patentable. However, the outcome must be more tangible than just mere data. What Justice Emmett has characterised the required limb as information of economic significance once entered into or produced by the means of a computer that becomes an economically valuable, artificially created state of affairs, and thus patentable. Of greater issue is the very nature of these correlations. They change, and they change with alarming regularity. That they're dependent on the sequencing of the individual and the reference sequence that's used. Under Australian law, a patent must disclose the invention in a manner which is clear enough and complete enough for the invention to be performed by a person skilled in the relevant art. And the claims must be supported by matter disclosed in the specification. A patent must also be useful, albeit with a low threshold for what is useful. For GWAS inventions, this requires description of the process, similar to the biosimilars, of comparing the sequences, the relevant significant sequencing, and correlating the identified sequence matrix with the result identified in the claims. The utility problem arises where there is presumed sufficient information which, when followed, does not produce the reclaimed result because of the proprietary database. The problem is that IP Australia is not well placed to question the reproducibility of these claims because its assessments are essentially made on the basis of lodged complete specification and any publicly available data and information, the prior art. The relevant standard applied by a patent examiner is that balance of probabilities. In practice, there's a genuine doubt about the correctness of the objection, particularly for GWAS studies, because there are significant doubt issues, both in inaccurate data and a problem with properly recording the steps in analysis, the computational experiments, and the algorithms that are used to extract the data. Both these problems mean that many of the results are either not scientifically reproducible or are retracted almost immediately as soon as they're published. The key challenge for addressing genetic basis of disease is to resolve the inherited phenotypic variation or heritability in a population, or how much of that disease how much of the disease among the variation in the population is attributable to genetic factors and how much is lifestyle and environmental factors. This quest has been eagerly pursued through big GWAS projects and with the development of biobanks, but the results have been disappointing and non-reproducible as they rely on those databases and are fundamentally shifted as new profiles are added or new correlations are found. In the popular media, this means with the rise of direct-to-consumer testing, you go to bed a Viking, you wake up finding out that you've got a predisposition to Parkinson's. Nothing has changed except the database that was used. It's clear from the case law that the subject matter of a claim must possess a quality of inventiveness that distinguishes it from a mere discovery or observation of the law of nature. At this stage, it's arguable that despite early promise, GWAS will only ever offer observation and mere discovery, and is still largely exempt. There are also problems enforcing the patents, given that research is largely experimental and infringement exempt under the research exemptions. Thus, the effect of having a patent over such claims in Australia is possibly limited insofar as it relates to companies being able to enforce their rights over researchers claiming that they're engaged in experimental activity, which otherwise may infringe. There's also an ambiguity in the thresholds required for personalised medical treatments that arise from GWAS or genomic research that target pharmacological researchers. And again, very similar to the biosimilars that we heard about earlier. While diagnostic methods and treatments are largely patentable, one of the outcomes of Cancer Voices was to articulate that for claims involving new disruptive innovations, those unimagined technologies with unimagined characteristics and implications that don't fall squarely in an established class or product or process, the court is likely to weigh public interest and consider the state of intellectual property outside of Australia. Bruce stole my quote from Justice French. But we need to make sure that we ensure that unconstrained access by medical practitioners and their patients to new methods and processes. Thus, courts both domestically and internationally are becoming increasingly reluctant to uphold or grant patents that limit the public good benefits. While this has traditionally been a feature of European courts who do have an active opposition process to patents, the increased publicity against patent trolling for pharmaceuticals in particular and the public concerns have led to increased opposition to medical patents, both treatment and epigenetic research. Given the uncertainty for researchers and biotech investors, copyright may offer a solution, rethinking our doctrinal notions about the separateness of copyright and patents. Though copyright and patents have never been declared mutually exclusive, courts have usually found that patent law protects the idea, whereas copyright protects the expression. As a cultural artefact, we think of patents as industrial, as science, whereas copyright belongs to fine arts and literature and drama. However, increasingly broad scope of copyrightable subject matter may offer opportunities. Unlike patents, copyright arises on creation, without any of the formalities once an idea is reduced and fixed in material form, provided it is sufficiently original. Therefore, copyright is available in the scientific outputs, that sequence of DNA represented in written format, using conventional terminology or contained in a sequence database. Copyright protects only the written work. It doesn't need to be of high or artistic value. Copyright has been granted for telephone books, for betting slips, for restaurant menus. DNA sequencing, and particularly rDNA and cDNA and protein molecules, are modified by a researcher that expends skill, effort, judgment, and the proteins expressed are in a fixed, albeit electronic form, that are in a recognised language that has meaning. Although not a page-turning read, it is a literary work and thus copyrightable. Similarly, it's been argued, and I was interested in your question before, that genetically modified organisms or the proteins expressed can obtain protection as artistic works. In particular, either as sculptures or works of artistic craftsmanship, or as art. In one of the earlier slides, I had a really pretty picture of the HeLa cells. Thus, both images and molecular models may be art. Again, copyright is not limited to permanent works, only fixed works. Copyright has been granted in living art, such as people and trees. While there are issues, it is certainly worthy of further consideration. By far the greatest opportunities for researchers and copyrightability of their work lie in the biodatabases necessary for genomic research, particularly given the huge variations in research outputs. In Europe, a sui generis database directive provides 15 years of protection for the contents of databases and significant updates. While there's ambiguity, new variations would appear to be well within the defined case law of a significant update and thus could extend that protection in perpetuity. In Australia, database protection is also relatively uncontroversial, following Telstra and desktop marketing. While the thresholds for originality remain low, namely that it must be a result of particular mental effort or expressive of inventive thought and cannot be dictated essentially by the nature of the work. While later courts have been more cautious, it's argued that these judicial standards are easily met in genomic research and in the associated databases. Similarly, in the US, compilations and database protections are becoming increasingly available, although again more ambiguous. In a compilation, protection may be extended to the selection, coordination and arrangement in the work as a whole if it demonstrates some level of originality. While FEAST required only a minimum spark of originality, increasingly decisions have protected both the selection and arrangement and also the non-protectable content that forms part of that arrangement. However, for individuals in Australia and internationally, courts and policymakers have considered non-proprietary rights and proprietary rights under doctrines of contract law, consumer protection as patients with tortious or equitable rights, donors under property law, or citizens with human rights, all with very, very different outcomes. It's arguable that opportunities exist under the intellectual property copyright regimes which have not been previously considered or explored, particularly for participants in genomics, as it combines both their genetic material with vast swathes of consumer-provided information. Participants are invited to fill in questionnaires about diet, exercise, hereditary and other familial information, emotional status on any given day, preferences, link their health data, link their Google data and location data, and also their Fitbit. While the impact of such curated personalities has been explored in other digital economic platforms, for example with cam girls or Instagram personalities, it's arguable that these profiles are literary works requiring both skill, judgment, effort, and some understanding of how that information is presented. Thus, it's arguable that participants can be considered commissioners or as co-authors of their data, with attached intellectual property and non-proprietary rights. More importantly, given the fundamental rights of copyright to control the right to communicate to the public, to assign, to license, to gift their proprietary data, and have moral rights over how the work is attributable or used, they may provide people with rights to control their data in ways that haven't been explored yet. In 2000, Donna McLean filed a patent application covering herself in the United Kingdom, in other words, asserting self-ownership of herself as a suite of genetic data. In public discussion on the unusual application, the UK IPO stated it's not really worth patenting yourself or something unless you can make a lot of money from it. But as Ms. McLean recognised, her genes could be used in medical research to extremely profitable ends, and her data even more so. It may be that copyrighting oneself as a living database will provide activists such as Ms. McLean with self-ownership in her digital personhood, protecting autonomy, control, privacy, and enabling human dignity in a biodigital age.